those schools for allowing us to visit with their students about our jobs and the work of Kansas courts. Just today, we visited Pittsburgh State University, Independence Community College, Cherryvale Seniors and Middle Schools, the Southeast High School in Cherokee, Independence High School, Field Kindley High School in Coffeyville, Sedan Junior and Senior Highs, and Girard High School. And we'll visit more tomorrow. We estimate that we'll reach around 2,900 students over the 2 days. We also met earlier today with local attorneys and visited with them, and we welcome all those attorneys who have joining us again tonight. This afternoon, I was able to go to the Justice Center here in Parsons and down to Oswego to the clerk of the court's office in the court services office down there and visit with our hardworking staffs. I learned more about the outstanding and hard work that your judges in this county and this area are doing and how hard their staff are working. You should be very proud of what they've done. Your judges are among the statewide leaders in an initiative about which I am very passionate, and that is starting behavioral health and mental health treatment courts, where judges, court service officers, and other team members work to connect to help address behavioral health issues that lead people to being in our courtrooms. These courts have an incredible success in dramatically reducing recidivism. I want to thank the leadership of your district for doing that and for Judge Johnson and all those on his team that are involved in that. Your judges are also statewide leaders and really starting and pushing us to start on a statewide basis a program to deal with rural justice issues and primarily with the lack of attorneys in rural areas, so that you and your community members have difficulty in accessing justice. We hope to, through the work of this new initiative, improve access to justice for Kansas all over the state and really focusing on rural Kansans. Now, this evening, you have a chance to see firsthand what the Supreme Court is, what we do, and how we do it. We are delighted to have this opportunity for you to learn more about how Kansas courts work. Before we get to those cases, though, I do want to thank some people who have made the events of today and tomorrow happen. I will start with a couple of people who you've already met. Mr. Doug Shima, the clerk of the Kansas Appellate Court. Without Mr. Shima's outstanding work and that of his staff, our court could not function day to day. They keep us running. And when it comes to oral arguments like you'll see today, Mr. Shima organizes them, he assists the attorneys and us in making them happen. So we're very thankful to Mr. Shima for the work he does for us, not only for this trip, but every day. I next want to recognize our honorary bailiff for tonight's docket, Rick Turner. Imagine many of you know him, but we tonight pause to recognize Mr. Turner's service to courts and to the administration of justice. Before his retirement, he worked in private practice for 49 years and as a city attorney for St. Paul for 47, the city attorney for Oswego for 16, the USD 506 attorney for 17 years. Even that alone is pretty monumental. But he continues to serve as a municipal judge in Parsons, a position that he's held in 1988. He has also served on the 11th Judicial District Nominating Committee, the committee that helps select the judges, for over 40 years. On his retirement, his colleagues referred to him as an outstanding attorney. They described his incredible character, his reliability, his trustworthiness, and his high integrity. We are honored to have such an outstanding member of the bar open court for us. Thank you, Mr. Turner. I would, of course, like to thank all of the judges of the 11th Judicial District, which is Cherokee, Crawford, and Labette counties. who have helped us with the school visits today, and we'll do some more tomorrow. In addition, we brought out of retirement Judge Bob Fleming, who helped with the school visit today, and our good friend, Chief Judge Dan Kreitz from Allen County even came over to help with some of those visits. So thank you to all of you for that. And I want to thank Terry Meador, the Lebec County Clerk, and her staff who are helping tonight with programs and in the morning with some of the other events that are going on. So a special thanks to them. And finally, the final group I would like to recognize are the law enforcement officers who you've seen outside and inside, and this various security personnel who are helping us. Those include the Parsons Police Department, the Lebec County Sheriff's Department, the Kansas Highway Patrol, the KBI, and KC Protective Services. So thank you all. Tonight, as you came expecting and have heard, you will see actual court proceedings in two cases. As you now may know, the Supreme Court proceedings are called oral arguments. Attorneys will present legal issues in support of their client's positions. The attorney for one party will argue first, the other side will respond, and then the first party will have the last word. Justices will ask the attorneys questions to learn why they believe the law supports their client's position. This interaction helps us meet our duty to enforce the rule of law and make decisions the law requires. The parties have presented their written briefs and cited the laws that support their positions. This might be the U.S. Constitution or the Kansas Constitution, or the law that may form the basis for these suits through statutes. Our role as judges is not to evaluate whether any of those laws are good policy. That is the job for your legislators. Our obligation is to set aside our personal beliefs, our politics, our special interests, and even public opinion. That means, for example, tonight, we will not do a public opinion survey or ask you to tell us how you think these cases should come out. We have to remove ourselves from all of those influences because our job is to take the facts of the case, apply the law as written by the legislature, and in a fair and impartial way for all Kansans make the decision. As Thomas Jefferson said about 200 years ago, the most sacred of duties of a government is to do equal and impartial justice to all its citizens. And our oath obligates the members of this court to do that. And that's what we set about to do every day. So we hope you leave this evening with a better understanding of the contribution of the lawyers and the judges in furthering the rule of law, and that you will leave with a better understanding of the role of fair and impartial courts in our country. So now, just before we call the docket, I would like to introduce my colleagues and let you know where they come from, as we are all native Kansans. I would mention first that I grew up in the far northwest corner of the state in Goodland, so just about as far as you can get on a diagonal from where we are today. This will kind of be a ping pong back and forth because we sit in seniority, with the most senior justice on one side of me and the next senior on the other, and then it continues down the road. So pretend now that you're watching a tennis or a ping pong match, and we'll start the process. Justice Rosen, Eric Rosen, who hails from Topeka. On this side, Dan Biles, who grew up in El Dorado. Back over here, we have Justice Caleb Stiegel from Lawrence. Evelyn Wilson, who is a native of Smith Center, Kansas. The far end, KJ Wall, who grew up in Scott City. And then at this far end, another Lawrencian, I think is the way we say it, right? From Lawrence. So we're all very pleased to be here tonight and look forward to visiting with you. So I will now ask Mr. Doug Shima, the clerk of the Kansas Supreme Court, to please call tonight's docket.
Thank you, Your Honor. May it please the court. The docket for Monday, October 3rd, 2022 consists of 2 cases. The first case is appeal number 123077, State of Kansas versus Richard I. Mohler II, Sedgwick County, briefs both sides.
May it please the court, the appellant Richard Mohler appears through counsel Casper Shire, Kansas Appellate Defender Office. And Chief Justice, could I please reserve 3 minutes for rebuttal today?
3 minutes is reserved. Thank you.
Thank you, Your Honor.
May it please the court, the state of Kansas appears by Assistant District Attorney Lance Gillette.
Second case, appeal number 120566, State of Kansas versus Justice Justin Burke Eckert, Miami County, briefs both sides.
May it please the court, the state appears by Elizabeth Sweeney Reeder, Miami County Attorney, and I'd like to reserve 3 minutes for rebuttal.
3 minutes is reserved.
May it please the court, Kai Mann, on behalf of Justin Eckert from the Kansas Appellate Defender's Office, ready and present for argument.
Thank you. Thank you all, counsel. As the attorneys settle in, I will make one more explanation. I want to explain to you that the justices are familiar with the facts of the case and the parties' arguments. As I mentioned, we've reviewed the briefs. We've also reviewed portions of the trial court records in these cases, or much of those records. You will see that many of us have computers or papers in front of us. And so we may at times be looking at those and taking notes. What we are doing when we do that really is to consult our own personal notes, checking things in the briefs, sometimes checking a case or a statute or looking at a portion of the record. We do this to assist our understanding and the processing of the attorney's arguments. But we want to assure you that we are still listening as we do that. And I think you'll find that to be true, as we usually have a few questions for counsel. So with that, I will call the first case of 123077.
Good evening, Your Honors. Once again, I'm Casper Shire appearing for Richard Mohler. Richard Mohler appeals 2 jury trial convictions for violating the Kansas Offender Registration Act, KORA for short. Richard was arrested for driving a red pickup with a suspended license in March of 2019. Arrested a second time for driving a gray sedan with a suspended license in June. At Richard's trial, the state presented no evidence owned either the pickup or the sedan, or that he regularly drove either the pickup or the sedan. Richard completed the quarterly registration required that KORA requires in both March and June 9th. And he testified at his trial that he told registration officials about both his March and his June arrest, and that he told those officials that he did not own or regularly operate either the sedan or the pickup. He completed the registration paperwork that the registration office helped him prepare, which did not include any information about those vehicles. All seemed well until August of 2019, when the state charged Richard with 2 counts of violating KORA for not registering the pickup he drove a single time and the sedan that he drove a single time. It has been the state's theory of this case that once is enough, that driving each of these vehicles a single time obligated Richard to register those vehicles under KORA. They made that explicit in their opening argument and throughout their case. It's our position, of course, that once is not enough, that it is, as a matter of law, the state needed to prove more. They needed to prove regular operation. They needed to prove a pattern of driving. And because the state did not do that, we are asking this court today to reverse Richard's 2 KORA convictions.
Let me ask you to address the state's argument about standing. In other words, the state says you're not even entitled to make this argument about regularly driving the vehicle because you didn't prove you only drove it once. What's your response to that?
I have several responses, Your Honor. The first is that it flips the burden of proof. In a criminal prosecution, it is the state's job to prove that Richard is guilty and not Richard's job to prove that he is innocent. in that sense, it's not particularly important whether Richard proved that he drove the car only once. The problem the state has is that they proved that all they proved is that the vehicle was driven once. Second, typically for standing, what you need to have is a grievance before the court. And Richard's grievance is that he's sitting in prison right now. He is seeking to challenge the sufficiency of the evidence presented at his own trial, not to challenge the rights of some hypothetical third party. And this court's case law is clear that you always have the ability to challenge the sufficiency of the evidence at your own trial.
They say that all they had to prove was that he drove the vehicle at least once, which is what they did. And for you to be able to make your argument about the interpretation of the statute, that you need to show he only drove it once as a matter of fact. How do you respond to that?
Well, apart from the arguments that I've already presented, Your Honor, I think it's a circular argument because the state is essentially getting to the merits of this case. The state is saying that because Richard didn't meet the burden of proving that he only drove this vehicle once, that he's not protected by the statute. And of course, the problem there is if the statute requires the state to prove that he drove the vehicle more than once, they didn't do that. So I think it's couched as a standing argument, but I think it actually goes to the merits, Your Honor, and I think the court has to get there.
I have one other question and then I'll be quiet. Is this statute ambiguous? Because Judge Malone, when he dissented, said it wasn't, and that kind of made me scratch my head a little bit. But what's your position on that?
My position, Your Honor, is that the word operated in a vacuum certainly is ambiguous. It can mean either one-time operation or operating a vehicle regularly over time. However, I think the statute, when viewed in its totality, is not ambiguous. I agree with Judge Malone because the word operate is paired with owned. It's in a clause with owned.
Can I interrupt at that point? It's disjunctive though. And what do we take from that? It's in that phrase, as well as the other connector, it uses or twice. It's owned or operated by the offender, comma, or any vehicle that the offender regularly. I would understand your argument if it was owned and operated. So can you, as you finish addressing Justice Biles' question, can you maybe kind of meld it in with that consideration as well, please?
Sure, Your Honor. I think the best way I can describe it, at least as I see it, is that since owned and operated are part of the same clause, owned helps to inform what operated means. Owned and operated is a term of art, in a sense. And furthermore, that the next clause, or that the offender regularly drives, informs what that entire first clause, owned or operated, means. I can, you know, are we talking about two discrete elements here? Or are we talking about three discrete elements here? Well, either way, no matter how you look at it, the odd man out, so to speak, is interpreting operated as one-time operation is enough.
Counsel, can I interrupt you? Sorry, that was a little loud. But how do you define operate then? So you're suggesting then operate in the statute, there are two clauses. You have to register if you own the vehicle or if you operate it. And then there's the second phrase, or regularly drive that vehicle either for personal use or in the course of employment. So I'm talking about the first part of that phrase. You're suggesting because it's coupled with ownership, the definition of operate that the legislature intended to use really defines the legal relationship of the individual to the vehicle. They can either own it, have title, or they can operate it, meaning maybe a leasehold arrangement, more of a, I don't know, the transportation industry definition of operate. But how do you specifically define the term operate in that statute?
I think that's a great question because it gets right to the heart of what all this is about, Your Honor. And it's essentially what the Court of Appeals did here, is they took the definition of operate from DUI and plugged it into the statute and said operate means drive. We're done. That's all we need to do. And that is not the right approach. It's our position. First of all, because operate in the DUI statute, that's a criminal statute and not a civil regulatory statute. But second, because operate in the DUI statute is not coupled with owned and is not paired with regularly drives. And building on your question a little bit, Your Honor, yes, I think operate does, when viewed in that context, when with those other items in the list, operate implies some sort of an ongoing authority to drive a vehicle, not merely a one-off driving event.
So control and dominion over the vehicle would, in a short phrase, be how you would define operate, given its proximity to ownership in the statute.
Yes, Your Honor, I think that would be a reasonable way to interpret it.
Is that in conjunction with looking at the things that a person is asked to complete on the registration form if they are going to declare this operation, which includes all kinds of details about the vehicle and where it's garaged, and so they are the person that can answer those questions and know those questions? Is that a guidepost for us with that interpretation?
I think it has to be, Your Honor. And I'll give an example. I drove up here in a rental car from Topeka tonight. I should say drove down here from Topeka. It's tagged in Arkansas. To be perfectly honest with the court, I don't know what the tag number is. I don't know where the VIN number is. I don't know where that vehicle is regularly parked. If I'm somebody subject to CORA, I should not be forced under penalty of imprisonment to turn over to the state information that I simply don't have. Because as a one-time driver of that vehicle, I don't know those things. And most one-time vehicle drivers are not going to know those things. And, you know, I can certainly think of situations where this becomes very important. Let's say that somebody subject to CORA registration confronts a medical emergency and drives somebody to the hospital. Well, they should not be subject under penalty of imprisonment to turn over information that they're simply not going to have about a vehicle that's not yours and that they drove only one time.
But I think the state would say that if that happened, that example that you gave, that the individual would just have to register within 3 days of the event.
But I don't know how they could, Your Honor, because
They just get the information and then they go register. Why can't that? Why can't he do that?
because I frankly, Your Honor, I just don't think they're going to know it. They may not have an existing relationship with the person whose car they've driven. That person may not wish to tell them. I realize that's not going to be the usual case, but it certainly could happen.
Is it your position, counsel, that operate means drive and drive means operate?
I think in the context of this statute, it has to mean something more than drive one time. I wouldn't disagree that operate means drive. The question is, what kind of a pattern do we have to show there? Is one time enough, or does the state have to show more than that? And obviously our position is that they have to show more than that.
Well, your problem with this statute is that it continues. It says or regularly drive. So you either have to make a decision whether operate means once and or regularly drive means nothing. You have to just wipe it out of the statute. We, of course, don't like to do that. Or we've got to figure out how to make this work. And so that's that your argument is operate has to mean something more because of the rest of the sentence in the statute, right?
And
Or
I
the
see-
element of regularly driving.
I see my time is up, Your Honor. Could I answer the justice's question?
Certainly.
Yes, that is our position. And at the end of the day, to the extent ambiguity remains, to the extent that the meaning of the statute is not clear, Richard needs to get the benefit of the rule of lenity in this case, which says that an unclear criminal statute gets resolved in favor of each.
And that's why I asked you about the ambiguity to the statute, because I was worried that we can't get to the rule of lenity if we don't find the statute ambiguous. Would you disagree with that?
I don't disagree with that, Your Honor, but I think the statute is, from our position, at worst, ambiguous. I agree with Judge Malone's dissent, where he essentially says, and I agree, that while the statute may not be as drafted as artfully as it may have been, it's clear enough that the legislature intended more than one time. But to the extent it's not, then the statute is ambiguous and the rule of lenity kicks in, Your Honor.
Mr. Shire, before you sit down, I want to talk just ask a question about the second issue
Certainly, Your Honor.
having to do with the stipulation. When we consider whether the evidence was sufficient, do we look to the sufficiency to support the allegations in the jury instructions, or do we look to whether the evidence was sufficient to support the allegations in the charging document?
I don't think it matters in this case because both the charging document and the jury instructions, the charging and document charged Richard with having a prior conviction. They listed it out specifically with the juvenile case number, but the charging document still says prior conviction. And the jury instructions say the same thing.
Well, didn't the charging document specifically describe the adjudication?
It gave the case number for a juvenile adjudication. It used a JV designation, which, you know, in the business, we know what that means. But the complaint, if I remember right, also said for a prior conviction to wit, or something to that effect before giving that case number.
And is this a jury instruction that's, how do we handle that? Is this subject to clear error? How do we handle this if we consider it an error?
We did not raise it as an instructional issue, Your Honor. We raised it as a sufficiency issue. I guess if the court is inclined to get there as a jury instruction issue, it would be clear error standard, but I will concede that we didn't raise it that way. We raised it as sufficiency.
Thank you, Mr. Shire.
You're welcome, Your Honor.
The statute doesn't delineate though, does it? Right? It doesn't make a distinction between an adjudication or a conviction.
The 49, I'm sorry, 4903, Your Honor, which says 4903 does not, but it does say that any person can with a prior conviction or adjudication, language to that effect. And then it references back to the definitions section, which I think is 4901. And in 4901, offenders required to register based on a conviction are defined in separate statutory subsection from those required to register for an adjudication. And there are distinct registration requirements, distinct registration terms, and all of that. So it is our position that they are two different things in two different statutory subsections, Your Honor.
Any other questions? Okay, thank you, Mr. Shire.
Thank you.
Mr. Gillette?
Thank you. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. If I may, Your Honor, briefly before I begin my argument, just wanted to tell the court I've had the honor of arguing before our appellate courts all over the state of Kansas, but this is the first time I've had the privilege to argue in Southeast Kansas. And as a young man from Fredonia, just down the road, It is truly a privilege to be here tonight.
Well, then let's see how you do with the first question.
Oh, well, fair enough.
I want you to assume with me that we've got an individual required to register who works as a mechanic or as a parking lot valet. How do they comply with this statute when you need all that information every time they sit and drive in a vehicle?
That candidly is a hypothetical that hadn't come up.
Well, it just
that I
came
can
up.
think,
I
but
mean, it really
it's-
just
it's-
came up
it's
right now,
for
but
us.
we've got to make the statute make sense.
Yeah, we do.
And that's the problem. And
We-
I don't see how this statute works in those two scenarios.
Respectfully, I think that would, I guess, be a choice left up to the offender. If he or she is an individual that works as a mechanic and they're in a position where they need to be they have to be the one that drives that vehicle every time, then it would be incumbent upon them to get and I'll get to this in a minute, but the limited amount of information that's necessary. We're
Part of
talking
it's where
about-
that vehicle gets parked.
Correct.
Do you really think the legislature wants sex offenders to be getting the information from random people on vehicles they're parking about that they're operating, to get their home address and their license plate and their insurance information, when we have said the purpose of this statutory scheme is public safety?
And I agree, the purpose is public safety. In this hypothetical, though, arguably the mechanic would already have the address. They would either know their client or they're going to accept payment from them, and that is going to be cash, credit, or check. Most people would be paying in a way that they would know. The other alternative would be, again, if that person chose to be in that field, that is their choice. The alternative would be to avoid that type of a profession where they know where this type of a requirement is so important.
Counsel, can I follow up on that
Yeah.
and maybe ask the question a little differently? If public safety is the animating policy behind the statute, what is the public safety purpose of requiring registration of a vehicle?
Because that is how this particular group of offenders, those that are deemed an extreme danger to the community, those that are deemed highly likely to reoffend, move about in our community.
So there's a presumption behind the statute that where the vehicle is, there the offender is.
In general, yes.
And so wouldn't it make sense for the legislature to, if that indeed is the intent and policy behind the statute, it strikes me that it requires that connecting the dots, that where the vehicle is, there the offender is. Otherwise, the public policy of public safety is not being vindicated. And if that's the case, it just seems fairly clear that you've got to have a tie between the offender and the vehicle that is more substantial than a parking lot attendant. And so if you could answer that, not from a technical statutory point of view, but from a policy, like,
Sure.
how does that vindicate the policy that we've just agreed is behind the statute?
Because what Your Honor has just illuminated is not the entire policy behind the statute. It's not just where the vehicle is. If that were the only impetus behind this statute, we'd just be lowjacking people's
Well,
cars.
how
It's
does-
where the car was as well. These people have 3 days to register after they operate a vehicle.
How is the purpose of public safety served by the registration of a vehicle that's driven once by an offender? Can you articulate how that serves the
Sure.
public policy of public safety?
Sure. If an offender, and there are a lot of different examples that can be used, but I think that perhaps the easiest is if a registered sex offender wants to borrow a car, they drive it one time. Well, they just so happen to commit sex offenses during that time that they're driving.
It won't matter because the registration requirement's not for 3 days.
Not in the instant. You have to consider the time factor here. A child that's abducted, do you think that they're going to be able to get a license plate or a VIN number off of a car? No, they could get a make and a model. They could report that to the police. Then the police could cross-check that with the offender registry and link a completely unknown offender otherwise to a crime.
So everything you just said makes sense if the offender drives the car more than once. And maybe we're just talking past each other, but I struggle to see how public safety is improved by telling the public after the fact that I drove a car that I'm never going to drive again.
I think I'll have two responses, and I hope that we're not talking past each other, because I think that we agree that public safety is the impetus behind this statute, and that in any interpretation that we get into here has to defer to that. In the hypothetical that I presented, it only takes once. My counterpart got up here and argued that once isn't enough. Once is absolutely enough for an offender that is dangerous, likely to reoffend. It does ensure public
That's
safety.
true, but the registration doesn't help at that point. It doesn't help because if it's only a one-time deal, the crime's already been committed. That's what I'm struggling to understand, because this is all about public notice. We want to tell the public this vehicle is driven by an offender.
I think you may have just hit on where we may be missing each other here. Public safety versus public notice. Notice is forward-looking. Public safety is all-encompassing. It also looks historically, and that is why this type of vehicle registration is important. If an offender drove one vehicle in the past, and then they committed a crime in it, it will show up in the registry.
You're saying that it would be evidence that would link that person to a crime for which there is an unknown suspect.
Correct.
Okay.
An investigatory tool or clue at the very least. And that does further public safety.
The additional problem I'm having is this language that we're wrestling with and that we can't make sense out of was put in the statute in 2011. And when the proposal to add this language to the statute was discussed by the legislature, the Attorney General and the KBI came to the legislature and the House Committee and said that the purpose of this was to have registration of the license plate number and description of any vehicle the offender regularly drives. And that's not the interpretation you want to put on this language.
Respectfully, Your Honor, I'm not aware of that particular testimony. I don't recall it from any of the briefing in this case, to be perfectly candid.
We do our own work.
And I understand that. That being said, what the Attorney General's opinion is and what ultimately ends up in the statute and what those words mean, that's up to the legislature and then this court to determine, not the Attorney General. And I think that
but it becomes relevant when you want to say that the statute only requires once to drive, but then you've got this dangling phrase out there that says or regularly drives, and or regularly drives, it becomes completely unnecessary if every time you get in a car and drive you have to register. And that's why the language doesn't make sense.
I can see the difficulty here, but I think I would have two responses. On their face, these words in the majority opinion from the Court of Appeals, they saw no ambiguity here.
They did. I'm sorry.
The majority saw no ambiguity here in interpreting operate on its face, both in comparison to our DUI statute which requires one time, and based on dictionary language, which again, there's no quantifier for operates. So on their face, this ambiguity is not there. And then we have to consider these things before we even start going beyond these words' plain meaning. Regularly drives obviously has its own plain meaning. I regularly drive, but those two don't always in every instance overlap. And that's part of the problem here. If I drive a vehicle, if I rent a car, or I'm a mechanic and I need to drive it 3-4 times, am I regularly driving that vehicle? No. But is it a tool with which I could move about the community and commit crimes? Yes. That is something that the public needs to be notified of and needs to be aware of. And at the very least, it would be in the registry as an investigative tool if we ever needed to look back in time.
I'm going to push back a little bit on that, counsel. You mentioned the DUI law. And it's been pretty clearly established in the case law. The DUI law talks about operating or attempting to operate. Operate means drive. So here, those two words are used. Own, operate, regularly drive.
Mhm.
And you just said here, as opposed to the DUI statute, operate means something different from drive, right?
If I
Isn't
said
that
that,
what you said?
that was absolutely not my intent.
So operate equals drive and drive equals operate.
Correct.
Then tell me, what is the purpose of having own or drive or regularly drive in the same statute, in the same line?
And I think we have to go back to public safety. The entire purpose of the Offender Registration Act is to cast a wide net, to get information that is on the whole fairly available, almost publicly available.
I'm sorry, I didn't ask a very good question. If you've got own or drive.
Sure.
You've already got every time he drives. What is the purpose of adding regularly drives?
I think that that comes into effect as we try to shed light on in our brief with the way that the offender registry itself works. If I own or regularly drive a vehicle, that vehicle is going to show up on my quarterly offender registration. It just is, because those two things talk about present and ongoing ability, access, dominion. I heard the word used earlier, over that vehicle and the chance to use it.
But isn't regularly driving always a subset of driving?
I think I would put those reverse. I think that drive would be the subset of regularly drives. It's basically tiered, and there was no dispute below at the Court of Appeals level that there are three different things here. We have owns, regularly drives, and operates. I would grant you, if those three things were in a different order, it might be slightly more clear, but even in the order that they're in, as Justice Eckert noted, that disjunctive or makes it pretty clear these are three different things. And we're talking about someone that, in my hypothesis is, and the examples in my brief, I can own a vehicle and never drive it. Happens all the time. Junkyard owners, car collectors. It's easy to own a vehicle and never drive it. Regularly operates. If I drive a cab, I regularly operate it. I don't own it. If I drive a farm truck, I regularly operate it. I may not own it. Then there's this subset of operates. And if I drive it once, I need to register because it's important for the public to know that I was in that vehicle.
I'm not sure, I'm sorry, if you're not finished, complete your answer.
No, I'm
Right.
finished.
I'm not sure the disjunctive is enough for your argument, because if the disjunctive was combined with commas in a serial fashion, we might get there. But the comma comes between two clauses. So you've got one clause without punctuation of ownership and driving, and then the only comma setting off another clause or regularly drives. I think your argument would be very clear if they had put a comma between ownership and drive, but they didn't. So it does seem to set that as a pair that some way relate to each other. And that's the struggle, I think, is what's that relationship have to be?
I see what Your Honor is saying. And again, a comma might make it clearer, but I think that these words have clear meanings on their face. And respectfully, they have to mean different things, because own and drive are two totally different things. And we cannot forget that drives is modified by regularly. There is a quantifier there. Clearly a quantifier there. There is no quantifier or anything associated with operates. So it stands alone. After the disjunctive or, could a comma have made it more clear? Sure. But is it necessary to make it clear on its face? Absolutely not.
I have a quick follow-up
Sure.
to that, on that exact phrase. I think we could agree that the phrase owned and operated shows up lots of places. It's a
Yes.
term of art in the law.
Sure.
Do you know of any other places where the term owned or owns or operates shows up in the law?
I don't off the top of my head.
I don't either. Is there a chance this is a drafting error?
I don't think so. The Kansas Offender Registration Act mirrors the federal Sex Offender Registration Act, and this is something. I mean, we
Is that
have
what
our
the
own-
federal act says, owned or operates?
I have not looked. That may be a place where we could look, to be
And-
perfectly candid.
And you're referring to the Adam Walsh Act? Is that the reference we would look to?
Correct, and the amendments there too, of course, but.
Mr. Gillette, before you sit down,
Sure.
I want to get a kind of a bigger picture here. The Kansas Offender Registration Act is a civil regulatory scheme. And there's always been a tension, at least with some of the members of the court, whether it is truly a civil regulatory scheme or it is a cross into a punitive statute. And tell me how, if a person drives a car once, never drives it again, how it doesn't cross that line into becoming a punitive aspect of CORA. I don't understand how it isn't.
I don't think that it does, because all that it would require if I drive a car.
You keep
once-
saying all that's required, as I think some of my colleagues articulate. It's just
Yes.
not a simple thing to go down there and talk about where a car is going to be parked where you have no idea.
That does, though, beg the question that whether every single detail is required, and it makes this thing.
If you
seem
don't
onerous.
provide those details, if you don't do this, in this case, for a crime this individual committed when he was 13 years old, is going to prison for 6 years. So yeah, the stakes are very high in these cases.
I
So
concur.
tell me how this doesn't cross the punitive line.
I concur. The stakes are very high. I don't mean to belittle this in any form or fashion. But if I drive a vehicle one time and I have 3 days, and it is respectfully a matter of going in and making the report, you could call ahead and see if that would suffice for your registering agency. I don't know that would work in every instance. But all it would require is to go in, hey, I drove this car, here's the tag and the VIN, and I don't know where it's regularly parked and I need to go. I don't think that that's necessarily that onerous. And furthermore, in my description of how, and I know I'm out of time, if I may, your Chief Justice, finish my
You
response.
may.
We were talking about how we have to consider this act in par materia. If I own or regularly drive a vehicle, it's going to show up on my quarterly reports. If I operate a vehicle one time, I'm required to make my report within 3 days of the ceasing to operate it. If I never operate it again, it's never going to show up again. It will literally fade into the history of that offender's registration past. Not necessarily, not even something that's necessarily going to, I don't even think it would be published on the website. That's the whole point, is just to put a pin in that point in time, just in case, and we move on with our lives. And that includes the offender. I understand it's something that a regular, ordinary individual does not necessarily have to do, but the individuals that are subject to this act are not regular individuals. As I noted, I'm well out of time. If there are any other questions, I would be happy to entertain them.
Any other questions?
And seeing none, I would ask this court to uphold the Court of Appeals majority in this case. I don't think that there is any ambiguity here. There's no need to move to arcane rules of statutory interpretation. These words have clear meaning. The Court of Appeals got this right. Thank you all.
Thank you, Mr. Gillette. Mr. Charlotte?
Thank you, Your Honor. I'd like to close with just 2 or 3 thoughts with the few minutes that I have left. First, if being subject to registration is, as a practical matter, precluding people from taking gainful employment, like being a car mechanic, like being a car valet, like being a landscaper, because they, as a practical matter, can't register all the vehicles they need to do their work, then it's starting to look a lot more like punishment than like a civil regulatory scheme. And I urge that court to keep that in mind as they interpret the statute. Second, the practical effect of asking registrants to report vehicles that they drive only one time is going to be to flood the registry with a lot of useless information. For example, if I am a registered offender and my friend John is nice enough to loan his car to me and I report it to the registry, even though I drive it only one time, John, who has nothing to do with the registry, and his vehicle, which he's going to continue regularly driving because he owns it, is always going to be associated with the registry because he was a nice enough guy to give me his car. And I don't think that's a result that the legislature intended. I hear this court struggling with what operate should mean in the context of this statute. And believe me, I've had that struggle too. Whatever it means, it does not mean driving one time. And I think it's important to remember that this is a case with facts where the state proved only that Richard drove each of these vehicles a single time. So whatever this court settles on, as long as operate means more than just drove it once and is never going to drive it again, Richard's convictions must be vacated. The state did not present enough evidence to support those convictions.
Which is the better alternative in your view? You'd win either way, the way I'm going to pose this. But which is the better view from a statutory interpretation standpoint? Would it be to say that defining operate as meaning only one time makes the rest of the sentence in the statute meaningless, which we don't do? Or to say that basically operate has to mean kind of the same thing as regularly drive, which is what I hear you arguing for. And if I've got those two choices, which is better? I mean, it seems to me if I go one way, you're going to have the rule of lenity with you because it really isn't fair to throw somebody in jail like this when we can't figure out what the statute means. But you seem pretty firm on wanting to interpret operate as meaning more than one time. And that's what I'm struggling with. Because to me, it's easier to say it's one time. The rest of the statute is meaningless. We don't do that. So we've got a real problem. So you see what I'm asking?
I absolutely see what you're asking. And as I said, Your Honor, I suspect I've struggled with this statute just as much as you have. To the extent that both of those approaches lead to the same end result, I don't think I take a strong approach on which of those is best, except to say, I think this court has to pick one way or the other. I don't think there's a third way to get out of this. So I think either way, whether you revert to the rule of lenity or whether you say, well, it's clear enough that the only thing it could mean is that operate means more than once, we end up in the same place.
Any other questions? Thank you, Mr. Trump.
Thank you, Your Honor.
Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement. I will now call the case of 120566. This is State of Kansas versus Justin Burke Eckert. Counsel.
Thank you, Your Honor. Good evening, Justices. For the record, again, state appears by Elizabeth Sweeney Reeder, Miami County Attorney. In this case, in May of 2018, a Miami County jury convicted the defendant, Justin Eckert, of several charges. The ones at issue today are the possession of drug paraphernalia charges. There were 8 counts of felony possession of drug paraphernalia and 17 counts of misdemeanor drug paraphernalia charges. The defendant appealed several different things to the Court of Appeals. But again, the issue that's tonight revolves around those charges. And that is because the Court of Appeals ruled in the defendant's favor on the issue of multiplicity of the drug paraphernalia charges. The state then requested that this court review that Court of Appeals finding that the defendant's possession of drug paraphernalia convictions were multiplicious. If the court finds that the convictions were not multiplicious, then the state and also Mr. Eckert's counsel have requested that the court then look at whether there was sufficient evidence to support the defendant's conviction for the felony possession of drug paraphernalia based on a propane, and also on a blower that were found inside the grow operation in the defendant's house. The first issue before the court is whether the defendant's drug paraphernalia convictions were multiplicious. I found it interesting when preparing for this that defense and the state agree on many things in this briefing. The first thing being the standard of review. We both agree that the court is, and this question is subject to unlimited review by this court. The defendant argued and continues to argue that these convictions were multiplicious. What is also interesting in this case is that this particular case was a situation where 2 different panels of the Court of Appeals has now ruled separately, one against the state, one for the state. And both of those cases actually arose out of Miami County. The Booten case was a case that I tried about 8 years ago, and the facts were so similar to this case. And we're asking this court to find that the Booten case is good law and that that should be followed by this court. In Booten, there was drug paraphernalia found in a house. He was convicted of the drug paraphernalia charges and then appealed, saying that these convictions were multiplicious. The multiplicious definition being when a single offense is charged in more than one count of the charging document, potentially subjecting an accused to multiple punishments for a single crime, which of course we could not be punished more than once for a single crime because that would violate double jeopardy. The test for determining if convictions were multiplicious was set forth in the case of State v. Schoonover, which again is something that defense and state both agree on, that the test that we're going to be using is set forth in this case. The first step of the case was, does the convictions arise from the same conduct? And the state conceded early on that the convictions all arose from the same conduct. They were all from the same search warrant. All the paraphernalia was either found in the defendant's grow room or throughout his house. It was all on the same day.
Can you get separate charges for each seed in a bag of seeds?
Each seed in a bag of seeds.
I'm reading the drug paraphernalia statute. It would seem to me that each seed in a bag of seeds would constitute a separate charge for the same marijuana production and just activity.
I think the seeds would actually fall under the marijuana itself.
What if it's 1,000?
I mean, I'm just looking at material to grow. Materials of any kind that are used cultivating, growing, producing, processing, or preparing. That sounds like a seed to me.
And I admit, Your Honor, I have not ever thought of a seed as paraphernalia in my charging. It's been sent to the lab, tested, and thought of as the actual marijuana.
what if it was a frugal drug entrepreneur that went into Sam's Club and bought a big bulk 1,000 pack of Ziploc baggies? Now we don't have the confusion about the seed, but is that 1,000 counts of possession?
I think it can be. As a prosecutor, I would not charge 1,000 counts of that, but I think that the way the statute is written, that it could be. Because it would be multiple items, and the way the statute reads, it should be unlawful for any person to use or possess with intent to use any drug paraphernalia. That any modifying the term drug paraphernalia, I do think that it could possibly be that. That because if we have more than one pipe, charging more than one charge of possession of paraphernalia for one pipe is something that is routinely done and has been done and has been upheld before by the Court of Appeals.
How would you respond to the Court of Appeals argument that, which criticized the Boonton Court for saying that the Court of Appeals in Boonton failed to consider 215701, which defines drug paraphernalia instead of relying on 5709, any drug paraphernalia. It defines it to mean all equipment. Therefore, drug paraphernalia is under an umbrella.
Respectfully, Your Honor, I think that they did not, that they were not looking at it correctly, and that the any, where the any is in the drug paraphernalia statute, the possession of drug paraphernalia is modifying the drug paraphernalia, the word, whereas when you're looking at the description of what the different drug paraphernalia is, that all is before. So I think that the drug, I believe that the way the drug paraphernalia statute, the definitional statute would read, would include all, because it says all, that's all encompassing all these things. And the any, it uses the any again to modify drug paraphernalia, which would be separate charges. Or
So
could be separate counts.
Does any mean one or some, or can it mean both?
I think the way that it has been interpreted, it means the same thing as each. Any or each. When we look at
Where does it say that?
I'm sorry.
What's your authority for that?
The authority for that would not be a specific definition that says any equals each, but rather looking at the other cases such as Odell or Houseworth, when we've had similar statutes that have used the term any, and it's all been interpreted to mean separate counts.
Should we look it up in the dictionary? Would that be authoritative?
It could certainly be looked up in the dictionary, Your Honor. Yes.
Do you agree that would be authoritative?
I think that the prior case law would be more persuasive than the dictionary.
So you think there is a case that says any equals one?
No, I'm sorry if that was the way that came out. I don't think there is a case that specifically says any equals one, any. But what I do think is that the case law that the Court of Appeals has done up until this point shows that any is to equal one conviction. That you can charge, it's the unit of prosecution, and that the unit can be multiple counts in a charge. Going to that second point of, or the part of the second part of the test, which is the unit of prosecution test.
So it could be 1 seed or 5 seeds or 100 seeds, depending on how the prosecutor defines it.
I think that's correct, Your Honor.
Is it a reasonable interpretation that in the legislature intended in 5709 to essentially incorporate the definition in 5701 so that it is essentially saying the intent to use any kind of drug paraphernalia? Because that is the language of the definition. Any kind is the wording that they use there. And does that change the meaning if that's true? Does that become all encompassing again?
Right. I don't think that, I still don't believe that doing any kind, I don't think that that means that it precludes having each item. So I don't agree that it changes the analysis.
Does it make it ambiguous?
I don't think it does, Your Honor. Certainly this panel of the Court of Appeals did. However, prior panels that have addressed the word any did not find it ambiguous.
I can think of one way that it might change the analysis and get your reaction to it. Is there a difference between 10 baggies and 10 different items of paraphernalia? A pipe, a scale, a syringe, fill out the blanks for the rest of them. They're all different items. The number's the same, but in the first example, they're all the same item. And in the second example, they're 10 different items. Is there a distinction in the statute between those two things?
In the statute, I don't believe there is, Your Honor. I think that that's, as a prosecutor, I would draw a distinction between it. I mean, I can tell you all, I've never charged 10 counts for 10 separate baggies, but I think the statute would allow.
Well, if the language is interpreted to mean any kind of paraphernalia, wouldn't that draw a distinction between those two scenarios?
I do think that would. Any kind, if you're talking about a bag and 10 baggies or a pipe, I think at that point, though, there could also be distinctions between pipes, different kinds of pipes. The baggie is the easiest one to look at with that particular definition or explanation, because the baggies, presumably, we're still talking about the bag from Costco that has the 10,000 baggies. They're all going to be the same versus a gallon bag or a sandwich bag. Gallon bag being for multiple or for large amounts of marijuana, the sandwich ones being for individual sales. Your Honors, I am out of time. Is there any other questions?
I see none. Thank you, Ms. Sweeney.
Thank you.
Mr. Mann?
Good evening, and may it please the court. Kai Mann of the Appellate Defender's Office on behalf of Justin Eckert. Justin Eckert's state and federal constitutional guarantees to be free from double jeopardy were violated when he was convicted of multiplicitous charges of possession of drug paraphernalia. Specifically, his rights were violated upon conviction of 8 felony paraphernalia counts stemming from items used with the single intent of growing marijuana, and 17 misdemeanor convictions, all stemming from the single intent of personally using marijuana. The Court of Appeals carefully analyzed this issue, finding that the correct unit of prosecution is not the number of items possessed, but the intent for which they are possessed. This is the correct result, and Mr. Eckert respectfully requests this court affirm the Court of Appeals. In tackling this issue, the Court of Appeals disagreed with State v. Booten, the 2016 Court of Appeals case. The Booten court held that the word any dictated that each discrete piece of paraphernalia was the correct unit of prosecution, but the Court of Appeals panel in this case disagreed for 3 reasons. First, the authorities Booten relied on are not paraphernalia cases and are distinguishable from them. Second,
How are they distinguishable?
in Odell, the contraband or the taking contraband into correction facility, it was any item. So when you have the word any modifying a singular item, then that allows position to where any discrete item can be
But
charged.
this is any item of drug paraphernalia.
But drug paraphernalia is defined in the collective. It's defined as a plural sense. In fact, if you go through every single in 5701 F 1 through 12 and then A through P, all of those are defined with the plural. We have kits, which, as the Court of Appeals noted, by their nature contain multiple pieces. So at what point does each piece of a kit, for example, a kit intended or used for planting? If I have a shovel and a hoe and,
Testing equipment, that's Singular.
I think testing equipment could also be plural because equipment can also be more than one. If I have football equipment, wouldn't I have pads and a helmet and shoulder?
Right, but it says scales and balances, that's plural, but what if you just have one scale?
Then again, I think you could only have one charge, but I think if you have two scales and you could still only have one charge because the gravamon and the key to the unit of prosecution is the nature of the conduct prescribed. And here in 5709 and 57.
What about the, what's the name of the case? With the, Hulsey, with the 86 charges of sexual exploitation?
Again, that statute says any visual depiction, any singular item, which when you.
You just said that the first case was, the first case was distinguishable because it was plural, and now you're saying.
No,
this
no,
one-
no. Odell, any item. Item is singular. Odell, Halsey, and I always mess this one up. Odegabaro. All the word and all three of those cases, any, modify a singular discrete.
So you're
thing.
saying drug paraphernalia is plural?
Drug paraphernalia is a plural because it means all equipment and materials of any kind. Drug paraphernalia is anything. Literally, these pants are drug paraphernalia if I intend to put drugs in them to conceal them. Drug paraphernalia is anything. And so therefore, when you define this, the key of the drug paraphernalia statute is that it prescribes using certain items with the intent. The intent is the key of what you use these items with. And in fact, we see that there are problems with the charging, as the court of appeals also noted, that the only non-absurd way to look at this is to group these by intent. And the facts of this case show this. For example, we have 3 jugs that are 1 count. We have 3 containers that are 3 separate counts. We have lights, plural, charges 1, 2 fans, 1 count, papers, 1 count, even though they're multiple. The roach clip goes with the papers, but that's a separate count. But then we have 2 bongs, 2 counts, 10 pipes, 10 counts. There's no principled way to do this. And this ends up being quite just a really unreasonable hammer being wielded by the state, because once you look at this, particularly in the context of the misdemeanors when Mr. Eckert was convicted, every single one of those misdemeanor convictions carries a 12-month sentence in jail. If you had 100 pieces, 100 bags, let's go to 100 bags. You could go back and serve 100 years in jail for having 100 baggies.
That's not what happened here. These counts were all run concurrent, right?
They were concurrent, but that doesn't mean that it couldn't happen. And that doesn't mean that there's absurd results inherent in the state's construction of this statute. The only fair way, the only reasonable way is to look at the intent for which these items
So
are.
what's your best case to show that, that the legislature intended this, that the, let me see, I'm gonna phrase this correctly. That the unitary course of conduct should be based on intent.
The test is the nature of the conduct prescribed. And when you deal with drug paraphernalia, since it encompasses literally
Well, is
anything.
it, by statutory definition, is it only one offense? Is it several violations of a single statute?
Right.
So.
But Schoonover, sorry, I didn't mean to interrupt you, but Schoonover teaches us that the nature of the conduct prescribed is the test. It's not like, it's again with the battery, if I.
Right, so the nature of the conduct and your
Yes.
position is that the nature of the conduct means intent.
Within this specific drug paraphernalia statute, it's whatever you intend to do with the items.
What's
that
your
are drug
best case?
paraphernalia. My
Or-
best case, plainly would actually be the Court of Appeals opinion in this
Is
case.
there any other case?
What's up? Not that I can, not.
What about an out of jurisdiction case?
I did not look at our jurisdiction. In fact, I think the statute is plain. I think that the Booton court was incorrect when they.
What about the statute makes you think that?
Drug paraphernalia is termed in the plural. We cannot say.
So the
certain-
statute you're talking about is 5709B.
Yes, but we cannot look at 5709B without the definition of drug paraphernalia itself. The 5701 is not just a suggestion, it is the definition. It is what defines drug paraphernalia. Statutory definitions are definitions.
Okay, so tell me how the two work in tandem together to get to intent.
Okay, 5709B, it shall be unlawful for any person to use with intent to use any person to use or possess with intent to use any drug paraphernalia. Now, again, if drug paraphernalia is more than one thing, if it's any materials in any kind, then the intents
Can
are.
you slow down just a
yeah,
little
I'm
bit?
sorry.
I'm sorry.
But then the intents are delineated by whether manufacture, cultivate, plant in subsection 1 or store, contain, conceal, inject, subsection 2. Those are the two separate intents that we're looking at here. And the Court of Appeals noted in this case that those intents seem to be delineated amongst personal use and, a wider array, more
No,
of
I
operation.
understand that, but I understand that it was split into two. What I don't understand is that, for example, a pipe and a roach clip, okay? You're saying that you cannot charge, that would be, I know it was 10 pipes in this case, but let's just say a pipe and a roach clip. You're saying it would be multiplicitous to charge and convict your client of both of those.
Yes, Your Honor, because both of those are used to ingest drugs into the body. They're possessed for the same thing. Basically having a pipe and a roach clip is like having two pipes. You use them to ingest into the body. So that is the intent. And that's what 5709, it makes unlawful.
But it says with intent to use any drug paraphernalia, and those are two items of drug paraphernalia.
But drug paraphernalia, no, the list in 5701F 1 through 12 and A through P is not, it's an exemplary list. It doesn't include everything that's drug paraphernalia. Because again, drug paraphernalia means all equipment and materials of any kind. That list is not exclusive. So if there was any other thing that could be used for drug paraphernalia and is used for drug paraphernalia, again, my pants. If I put marijuana in my pants to conceal it, which would be a good idea, given the law enforcement presence here, my pants would become, they would be drug paraphernalia. Because again, it's any materials and kind, it's the intent that makes drug paraphernalia. Drug paraphernalia is not a discrete thing. Drug paraphernalia is anything anybody wants it to be, as long as you use it with drugs. So under that, so once we look at all of this, the only reasonable way to look at this is that the intent is what controls, because the intent is really what makes anything a piece of drug paraphernalia. And furthermore, to the extent that any can mean both, or can mean every, or it can mean all, as the Court of Appeals also went through, then that gives us into a rule of lenity problem in which the statute has to be construed in favor of Mr. Eckert. So again, it is our position that the statutes are plain, is that the intent controls and that the unit of prosecution is the intent, whether that intent be in B1 or B2. But even to the extent that we're not so sure about that, well, the rule of lenity kicks in and it needs to be interpreted that way anyways. So again, I think that the plain language supports Mr. Eckert and supports making finding and affirming the Court of Appeals. But even if not, it's certainly not clear the other way. And and then we get into a rule of lenity situation where we must rule and affirm in Mr. Eckert's favor.
I want to return to your answer to Justice Standridge's question about what authority you might cite to. You didn't mention Thompson.
Oh, well,
So I just wanted to know, are you now agreeing with the Booten panel's analysis that Thompson does not help us?
No, I am not. Sorry, I just slipped my mind on Thompson.
Okay.
Thank you. Thank you for reminding me. And I would note that Thompson's a little bit different because it didn't have that word any, which really seems to be the problem here. And it really seems to be where that ambiguity, if there is any, lies. But again, I think Thompson is exactly right, because again, it's about the intent. All of those things in Thompson, just like many pieces of drug paraphernalia, aren't illegal. You could go out and buy rolling papers. You can go out and, buy a kit intended to, to grow plants. It only becomes drug paraphernalia when you intend to use it with the drugs. And so therefore, I think it is the intent that is the nature that the legislature was trying to prescribe, and not just how many pipes you got. And with that, I actually have no more prepared remarks. I am more than happy to answer any questions from the court if there are any.
So are you, then if I understand your argument correctly, you're suggesting that we had two different situations where both people possess, let's say, a pipe to consume whatever illegal drug, that just because one person happens to have three different pipes that they, for whatever reason, like to use on different occasions versus the other person that just possesses one, that conduct's no more culpable under your interpretation, because the intent remains the same in both scenarios, and it's the intent itself that should define the unit of prosecution under the statute. Is that a fair summary?
That is a fair summary, Your Honor.
Okay, thank you.
So if there is nothing else, I would just ask this court to affirm the Court of Appeals. And I thank you very much for your time.
Thank you, Mr. Mann. Ms. Sweeney Reader, you reserve 3 minutes.
I wanted to go ahead and just touch briefly at something that Mr. Mann said regarding containers, bongs, papers, how the rest of the complaint was charged, and those things were multiple. That was going back to when we were talking about prosecutor discretion. Under the statute, those things could have been charged as individual items, but at some point, a prosecutor has to look at court efficiency, and also whether it's going to, for lack of a better term, do anything. For the misdemeanor counts, counsel was correct that you could pile those up year after year after year, but what's purpose is that going to serve? With the felony counts, you can only go so high, or additional charges do not make a difference based on the sentencing rules. And I just wanted to briefly speak to that. I also, in this closing time, wanted to briefly talk about the second issue of the court does find that Booten was correct, that there was sufficient evidence
Well,
for.
tell me how there is on that second issue.
Mhm.
And you charge possession of propane, is that right? Not possession of a propane tank,
Correct.
possession of propane. What evidence is there's any propane in that tank? In other words, I'll use an example I have a gas grill and I keep a backup tank of propane in case I'm grilling and I'm not paying attention and it runs out, which happened to me recently. Replace the propane tank and I stuck my empty one in the garage.
Mhm,
That tank doesn't have any propane in it.
mhm.
So why is there sufficient evidence in this case when there's no evidence at all of any propane in the tank? You know? Or I was thinking about this in terms of possession of alcohol by a minor, let's say, and you find the alcohol is in a bottle that you find in proximity of the minor. And there's no evidence whether there's any liquid content in the bottle at all. How are you showing that there's possession of alcohol in that case? And maybe it's different, but tell me about you charge possession of propane. I don't see
Well,
how
I do
you show
think that, Your Honor, as far as I think the alcohol could be dependent on what other factors were involved. Do we have a minor that's intoxicated next to the empty bottle? But that is kind of the same here. We have the propane tank that was attached to the heater that's in the grow room, and it would be a reasonable conclusion then that there was propane there. I agree it could have been worded better as far as a propane tank. I'm sorry, I don't mean the feedback here. But I do think it is something that a rational fact finder could have found for the propane and the blower. Given that these two items were connected, they were inside the room with the multiple marijuana plants, with the lights, with the tent, the fans to circulate, the moisture, water pump heater, a ventilation system, all of this together, the jury found was enough to say that there was propane in the tank. That was something that was asked in the facts that defense counsel brought out. Did you pick it up? Was it runny? What makes you think there was propane in the tank? And the jury still determined that there was enough there, given all the circumstantial evidence, to conclude that there was propane in the tank. I see I'm out of time. If I could just briefly remedy here. The state would request that you affirm the district court's ruling and the jury's findings and reverse the holding of this Board of Appeals panel that heard this case, that the drug paraphernalia convictions are multiplicious and find that there is sufficient evidence to sustain the convictions for the blower and the heater. I'm sorry, the blower and the propane. Thank you.
Chief, if I may, I do have one quick follow-up. I'm sorry. I think it's a quick question. It's a grammatical question. Does the fact that the word paraphernalia is one of those rare English words that is both singular and plural create an ambiguity in the statute? Just that grammatical fact alone?
I don't believe so, Your Honor. And it's because of the any
But you-
before it,
So you don't think it matters whether paraphernalia is singular or plural?
not the way the statute is written because of the term any. Are there any other questions? Thank you, Justin.
Okay, thank you. Thank you to both counsel for your arguments this evening. We will also take this matter under advisement. You have heard me say that twice this evening for both cases, just to explain a little bit more what that means and what happens next. The next step is that the court will meet and discuss the issues in the cases. We will make a preliminary decision about the outcomes of this appeal. And then from that, at the end of that conference, one justice will be assigned to try to put all of that on paper. Because one thing we do in every case is issue a written decision. So it's very transparent what we were thinking and why, what led us to the conclusion that we did. That, after that justice drafts that opinion, then the other 6 justices will review the opinion. So think of your worst nightmare of your English class or whatever it was, the teacher that had the sharpest red pencil. And you know what our lives are like. So as we review each other and pick apart the commas and the ors and the other wording of it, and it can be that we may not agree, in which case one or more of us might write a separate opinion. If we agree with the outcome of the opinion but disagree on the reasoning that leads us to that, it's what is known as a concurring opinion. If we disagree as to the outcome, we would write a dissenting opinion. And so that process, depending upon how straightforward and how agreeable we all are as we conference the case, could take a few weeks to, perhaps as many as 90 days or so for us to get a decision out. I'm sure all of you will be maybe curious to know what we do decide in that case. We always issue press releases when we decide a case. And then every decision that we make is on our website at kscourts.org. And so any decision that you read about in the news or are curious about that you have heard about, you can find it on that website. And then if you start to talk to your friends and neighbors about what happened tonight, and they say, oh, I wished I would have gone, no problem. In just a few days, these arguments will be linked on our website to the docket, and you can find those on our YouTube channel, just like you can find any of the oral arguments on any other case that you're curious about. Thank you for coming tonight. We really appreciate your attendance, and we will look forward to visiting with you at the reception that will follow in the theater's foyer. It'll take just a few minutes for us to get out there, but we'll be there prompt and as quickly as we can. We look forward to greeting you and visiting with you. With that, court is adjourned. One day would be shortest. Longest, I can give you a real accurate answer, but we have had some that take more than a year. Very rare. We try not to do that.